Hello my dear friends and welcome to Study IQ. I am Joycey Joy and today in this lecture we will discuss about the changes made to Form 26 and how these changes will make election candidates more accountable. Now coming to the current affair, the Law Ministry recently amended Form 26 in order to make election candidates more accountable. So this was according to the request made by the Election Commission of India to the Law Ministry. So Election Commission of India had recommended to the Law Ministry in order to make some changes to the Form 26 in order to make election candidates more accountable to the people. So according to the recommendation of the ECI or the Election Commission of India, the Law Ministry has amended or made certain changes to Form 26. So we will discuss about what are the changes made to the Form 26 and how this will increase the accountability and what impact it will make. But before we begin, this is our channel Study IQ and we are providing pen drive courses for various competitive examinations including SSC bank courses, UPSC optionals, SSC JEE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD grade A, UGC NET, UPSC civil services examination, CLAT exams, various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details or you can call to any of these numbers for more information. So let us begin. Let us understand first what is Form 26. So Form 26 is the affidavit that is required to be filed by a candidate who is contesting in the election. So it is an affidavit that has to be filed or that has to be produced by a candidate who is contesting an election. So what does the affidavit contain? It contains information on various details of the candidate like the assets candidates possess, about the liabilities of the candidates, about the educational qualifications of the candidates, about the criminal cases that are pending in which the candidate is also involved, and also if there is any pending public dues by the candidate, etc. So this information or the affidavit has to be filed by the candidate along with the nomination paper of the candidate. Now, it should also be sworn before an oath commissioner or the magistrate of the first class or before a notary public. And the sole purpose of Form 26 is to make the voters informed about the details of the candidate. So the voters can make an informed decision based on the assets, liabilities, educational qualifications, criminal background. So all this information will be furnished in the affidavit and this will be made public by the Election Commission of India and therefore the voters will have a clear understanding about all the details of the candidates and they can make an informed decision regarding to whom the vote has to be casted. Now let us understand what are the changes made by the ministry. Now earlier an election candidate had to declare the last income tax return of 1 year. So this income tax return is for self, spouse and dependents. So earlier it was for the last year or the past 1 year. Now the recent changes had made it mandatory for the candidates to reveal their income tax returns for the last 5 years applicable to self, spouse and dependents. So the IT returns for the last 5 years have to be mandatorily submitted along with the affidavit. Now another change made is that now they have to furnish the details of their offshore assets. So earlier the provision for furnishing details of offshore assets were not present in the Form 26. Now the offshore assets of the candidates also needs to be furnished along with Form 26. Now what is meant by offshore assets? So it means the details of any deposits or any kind of investments made by the candidate in any foreign banks or in any foreign body or institution and also the details of any assets or any liabilities that is held by the candidate in any foreign countries or abroad. So this is offshore assets. So it includes deposits, investments, assets and liabilities of the candidate abroad or in any other foreign country. So these are the changes made in the Form 26 and this changes are made intending to make more transparency or to bring more transparency and accountability of the candidates. Now coming to the objectives of the changes made. The first objective is that these amendments will make the voters know the extent to which a serving MP's income or assets grew in the last 5 years in power. Earlier the provision was that the last 1 year's income tax returns needs to be filed. Now the last 5 years income tax returns needs to be filed. Now this will bring in more information regarding the assets or the income earned by any serving MP or an MLA. So the voters can make an informed decision, and also it will help the voters to understand the criminal activities in which the candidate is involved. Now coming to the introduction of Form 26 itself, the objective behind introducing Form 26 was that it will help the voters to make a informed decision, and it will also make them aware about the criminal activities of the candidate. So this will help preventing people with questionable backgrounds from being elected to an assembly or to the parliament. Now with the recent amendments or the changes, the transparency and the accountability has increased. Now coming to the evolution of Form 26, in the 170th report of the Law Commission, which was submitted in the year 1999, the Law Commission had suggested that the government should take certain steps to prevent criminals from entering the electoral politics. And one of the suggestions made by the Law Commission in this regard was to disclose the assets and liabilities of a candidate before accepting the nomination. So this was the recommendation provided by the Law Commission in its 170th report, which was submitted in 1999. But what happened? The then government did not act on the recommendations of the Law Commission, and this later led to filing of a PIL in the Delhi High Court. So PIL is a public interest litigation, and a PIL was followed by the recommendation of the Law Commission. And on hearing of the PIL, the Delhi High Court directed the Election Commission to secure information on candidates. So this information shall be whether a candidate is accused of any offence punishable by imprisonment, regarding the assets and the liabilities of the candidate's spouse and also the dependents of the candidates, and also any other information that the Election Commission considers necessary. So the Delhi High Court directed the Election Commission to collect all this information of a candidate before accepting the nomination. Now following this, the central government or the union government appealed to the Supreme Court. But the Supreme Court also agreed with the decision of Delhi High Court. That means Supreme Court upheld the verdict of the Delhi High Court, saying that Election Commission should collect all the necessary information regarding the criminal background or the assets and incomes of the candidates before accepting the nomination. And in this regard, the Supreme Court had actually gone one step ahead of the verdict of Delhi High Court, and in 2002, the Supreme Court directed the Election Commission of India to ask candidates if they were convicted or acquitted or discharged of any criminal offence in the past, and also to seek information or details of assets and liabilities of the candidates, the spouse of the candidate, the dependents of the candidate, and also regarding the educational qualifications of the candidate. So Supreme Court added the information on educational qualifications as well. And after that, the Election Commission soon issued an order to implement the verdict. But what happened? The Union government again promulgated an ordinance diluting the order of the Election Commission. And this ordinance was known as the Representation of People Amendment Ordinance of 2002. Now, according to the ordinance, the candidate need to disclose the information only if she or he was accused of any offence punishable with imprisonment for 2 years or more in a pending case in which the charges had been framed by a court. And secondly, whether she or he had been convicted of an offence sentenced to 1 year's imprisonment or more. So these were the only two information that had to be submitted before the Election Commission while filing the nomination. So this was done by the central government by promulgating an ordinance in 2002 after the Supreme Court verdict, and later this ordinance was made an act. And also subsequently, the government amended the election conduct rules of 1961 in September 2002. And following this, the Supreme Court had declared the amendment made by the central government as null and void, Then finally, in 2003 March, the Election Commission of India issued a fresh order seeking information on all the 5 points mentioned in the Supreme Court order of 2002. So we have discussed about the Supreme Court order of 2002. So finally, Election Commission of India came up with a fresh order in which all the 5 details as mentioned in the verdict of Supreme Court in 2002 needs to be furnished by a candidate while filing the nomination. Now let us understand what happens if a candidate lies in an affidavit or if a candidate gives false claims in an affidavit. So we will see what are the different things that can happen. In the first case, if a candidate is leaving certain columns blank in the form 26, the Election Commission can term the affidavit as invalid. And it is a responsibility of the returning officer to check whether form 26 is completed or if there is any unfilled columns or any blank columns. And the nomination paper can be rejected if the candidate fails to fill it in full. And in case if a candidate has made any false claims or if the candidate has made any false statements in the affidavit through an election petition, the complainant can seek an inquiry. So an inquiry can be initiated through an election petition. And if the court finds the affidavit false, the candidate's election can be declared as void. So it is finally the court which has to conclude whether the statements were false or not. Now an example, in 2016, Patna High Court had annulled the Lok Sabha membership of Chedi Paswan. He was a BJP member for not declaring a criminal case pending against him. And there are also penalties for lying in an affidavit. So penalty can be imprisonment up to 6 months or fine or a combination of both. And also in this regard, Election Commission has come up with a new recommendation. Election Commission has asked the government to make the filing of a false affidavit as a corrupt practice or to term it as a corrupt practice under the election law, and this will make the candidate liable for disqualification for up to 6 years. But the central government has not taken any steps in order to implement this recommendation of the Election Commission. So if this is termed as a corrupt practice, the person will be ineligible for contesting the elections for a term of 6 years. You can find the PDF of this lecture on my Facebook page. And for any queries regarding your preparations, you can get in touch with me either on my Facebook page or you can email me at joyshi.studyiq@gmail.com. Thank you.